Everyone, I'm Lavanya from LEXIS and Company, working as an intern. Today I'm talking about aids to interpretation of statute. First is the internal aids of interpretation, under which the first is the title of the statute. There are basically two types. First is the short title, which is only the name which is given to the act for purpose of reference and identification. For example, Section 1 of CPC states that the Act may be cited as Code of Civil Procedure 1908. The Section 1 of the Indian Contract Act says that this Act may be called as the Indian Contract Act of 1872. The long title is the mention under certain acts whose purpose is to give a general description about the object of the act. However, it is not considered as a conclusive aid to interpretation of statute and it doesn't resolve ambiguity arising in words or expression under statutory provision but only provides a general idea of the act. Now, preamble. Preamble is a tool for internal aid to interpretation as it contains the main objects and reasons of the act. This rule of interpretation of preamble is that when a language of an enactment is clear and unambiguous, the preamble has no part of play. But if more than one interpretation is possible, a help can be taken from preamble to ascertain the true meaning of the provision. Marginal notes. Marginal notes are inserted side of the sections in any act which express the effect of the section, but they are not part of statute. They are called side notes and are inserted by drafters and not the legislatures. Headings. Headings are prefixed to the sections or a group of set or sections. These headings have been treated by the courts as preambles to those sections or set of sections. The rule of interpretation is that heading can't control the plain words of the provision, but if after the plain reading of the section more than one meaning is possible, only then the court may seek guidance from these headings. Explanations are given for the purpose of giving a particular meaning to a particular provision to remove doubts that might creep up if the explanation is not inserted. Definition or interpretation clause. It defines certain words used elsewhere in the body statute with the purpose of to avoid the necessity of frequent repetitions in describing the subject matter and extend the natural meaning of some words as per the statute. Punctuation. It is put in the form of colon, semicolon, comma, full stop, dash, hyphen, brackets, etc. Clause are generally appended in the cases of repeal and reenactment of the new statutes. It is inserted in the repealing statute, but the rights already created under the repeal enactment are not disturbed nor new rights can be created in it. Proviso is to a section has the natural presumption that enacting part of the section would have included the subject matter of the proviso. The proviso serves for four different purposes: qualify or exempt a certain provision, provide mandatory condition to be fulfilled by it to make an enactment workable, act as an optional addenda or become an internal part of the enactment. Last, exception, which is generally added to the enactment with the purpose of exempting something which would otherwise fall within the ambit of the main provision.